Hello, and welcome to another episode of Interactions, a podcast about law and religion and how they interact in the world around us. I'm Anna Knudsen.
And I'm Ethan Anthony.
And for this two-part episode, we had the pleasure of speaking to Peter Wozniak and Daniel LaChance about two death row cases relevant to law and religion.
In this first episode of 2, we want to talk about prisoners on death row and the RIGHT, right to death. The right, if there is one, for death row inmates to have a say in deciding the way in which they die. For this, we're going to be looking at the case of Michael Nance, a death row inmate who requested death by firing squad in the state of Georgia. By current law, death row inmates are allowed to contest the means of execution, which currently is by lethal injection.
But to do so, they have to come up with the alternative means of execution themselves. We'll be getting into relevant cases like Glossip v. Gross, how retributive justice unfolds in American prisons, and discussing the ethics of what happens when the burden falls on the prisoner to decide the way they die. In our second episode, we're going to talk about the RITE, right to death, the religious rites and rituals that accompany death made particularly salient in death row cases. For this, we'll be looking at the case of Ramirez v. Collier.
In this case, John Ramirez, a Texas death row inmate, requested that he be permitted to have his pastor present at his execution and to pray over him and lay hands on him. But Texas denied the request, and the case went to the Supreme Court. The question became whether Texas' denial represented a violation of the Free Exercise Clause of the First Amendment and a violation of RLUIPA. In this interview, we asked the question, what rights do religious inmates have on death row? You're listening to Interactions, and this is The Right to Death.
Peter Wozniak is the owner and founder of Wozniak Law, LLC, which is a trial-based law firm serving the metro Atlanta area. Wozniak is a graduate of Emory University School of Law and Candler School of Theology, where he received the Savage Levy Scholarship in Law and Religion. This is our interview with Peter Wozniak. I wanted to start, I was speaking with Daniel LaChance. I don't know if you know him. He's an Emory University law and history professor here. And he was talking about how the death penalty claims that we're seeing now are about having a level of dignity restored to the prisoners or the inmates on death row rather than challenging the death itself. And I thought that that was pretty telling given Ramirez v. Collier, the case that we're talking about today, because he isn't requesting to not be executed, right? He's requesting how he's being executed. He's requesting like a religious right. And so I was wondering if you could speak to us about Ramirez's request here. What is it that he's requesting? And what are the stakes to his claim? You know, like what were the stakes, I would say?
Yeah. So as y'all know, the court recently ruled on this issue in Ramirez v. Collier, and they found that Ramirez was likely to succeed on his claim under RLUIPA.
Right.
And basically that they found that he had a sincere religious belief or claim to have physical touch, that is laying on of hands, and vocal prayer during his execution in the execution chamber. And that because he had this sincere belief, that Texas denying him the right to those things substantially burdened his religious free exercise under the RLUIPA statute. And additionally, you know, they could have denied this right, but they had to show that there was no least or less restrictive alternative that they could have offered. And the court found that just a general blanket bar to his claims was not sufficient. And essentially they found that he could have, or rather that the state could have accommodated his requests in various ways that would have still, on the one hand, recognized or validated Texas's compelling government interest, which the court found that there was a compelling government interest,
Right.
while also protecting Mr. Ramirez's sincere religious belief or sincere religious claim.
This sounds like RLUIPA. Can you tell me a little bit about how that functions here?
Yeah, so RLUIPA is an acronym for the Religious Land Use and Institutionalized Persons Act. And essentially it was passed just over about 20 years ago, signed into law by President Clinton. And essentially it grants, among other things, people who are institutionalized, prisoners, essentially a religious freedom claim by statute, and once an individual can show that they have a sincere religious belief or claim that's being burdened, the burden then shifts to the state or the institution to show that there's no less restrictive alternative,
Right.
and to go ahead and accommodate the religious practice in question.
I remember we were speaking about this last week. The fact that the burden of the claim was on Ramirez and not on the state. Can you tell me a little bit about that?
So the court mentioned that Texas did not present a least or a less restrictive alternative, and it suggested that it was actually Ramirez's burden,
Right.
to suggest to come up with the least restrictive alternative.
Right.
And the court said that gets the analysis backwards, basically.
That sounds a bit out of left field to me, where it's like, why would it be Ramirez's job to come up with the less restrictive means? Like, doesn't that sounds like the state's job to me?
Right. Yeah, and I think it certainly is the state's job to accommodate prisoners, right, and to come up with a way that they can, in this case, carry out the execution and do it in a way that still protects their interests in an orderly and safe execution. And the Supreme Court gave several examples of things that could be done to make sure that the execution goes forward, like in an orderly and safe fashion. But instead of coming up with some solution like that, Texas just, barred all laying on of hands and all religious prayer. One example that comes to mind is the court saying that maybe, he could have touched the prisoner kind of on a different part of his body.
Yeah. I remember the quote was something like, are we going to have to go through every single part of the body and decide which part is okay and which isn't? Like, it got to this absurd capacity.
Right. Yeah, that's right. Yeah. So for religious touch, the court brought up allowing touch on a part of the body away from the IV lines, such as a prisoner's lower leg, that they could require Ramirez to stand in a location that gives the medical team like a good view of the IV lines.
Yeah.
And to be able to watch problems and quickly respond, and restrict the time period during which touching is permitted to minimize risk.
Right. So the point here is that there were other ways that the state could have accommodated his claim, and they weren't doing so. Is it clear why Texas wasn't doing so? Like, what was their motive? Do you know the motive that they had for saying we're going just like point blank not allow anybody to have any sort of religious person in the chamber?
So in this case, they were going to allow them to be in the chamber,
right?
Because the court had already ruled previously that basically you have to allow a person's spiritual advisor or clergy member to be present in the chamber. But this case extended the question to whether laying on of hands, physical touch, or audible prayer could be allowed. And I think a lot of these cases kind of have their genesis with prohibiting minority religions to be able to have their spiritual advisor present. If you look kind of back at the line of cases, because essentially there's a long history in the country, and the court noted this, of spiritual advisors or clergy persons being present during executions, offering prayers, giving guidance, that type of a thing. And then there were basically a string of cases. One of them was in Alabama, and another one was in Texas. The Alabama case basically dealt with an Islamic individual who wanted his imam to be present. The court actually didn't intervene in that case, and that individual, Dominic Reyes, was, I believe his name, was executed without being able to have his imam present. Not long thereafter, in Texas, an individual who was Buddhist wanted his advisor to be present, and it was in that case that the court intervened and said that basically you can't allow Christians basically to have their spiritual advisor to be present, but then not allow other religions like Buddhist people or Islamic people to have their spiritual advisor present. So that basically changed things. But then Texas's response was then to say, all right, well, we're not going to allow any clergy people to be present during execution, which then the court responded again in a later case and said that no, that actually that's not okay, because there is a right to have your clergy person present. So that brings us up to Ramirez v. Collier, where it wasn't in question whether a person's spiritual advisor or clergy person could be present, but now to this question of whether there could be audible prayer and religious touching or laying on of hands.
So you do think that there's a pattern of discrimination in the way these cases are being decided?
I think I think it's pretty clear in these cases that there was less of a desire to want to extend these kind of traditional rites to having a clergy person present to minority religions, right, or non-Christian religions. Because historically, again, this is something that was very common. And even in the Ramirez case, this is probably, I think, one of the most compelling facts in the Ramirez case, and that wasn't disputed, was that Texas had a history of allowing clergy person in the chamber and allowing physical touch and audible prayer, right? And then all of a sudden they're not allowing it. And so this really kind of hurt Texas's claim that they had no way of accommodating Mr. Ramirez's religious, claim or request, right?
Because it's like a basic precedent.
Like if they'd done it in the past and there hadn't been a problem, then why all of a sudden is this causing a problem? And so I think that fact alone probably went quite a bit into the court's thinking. On the other hand, the lower courts didn't necessarily question Mr. Ramirez's sincerity of his claim. That wasn't really in question. And that wasn't really the argument that Texas was going up against with a lot of vigor. However, Justice Thomas in his dissent, he wasn't buying it. He just he saw Mr. Ramirez's claims as being an attempt to essentially game the system, which is in the oral argument something that he was very concerned about. And then that came out in his dissent, that he thought that Ramirez was using religion as a tactic of delay, and his argument was that Mr. Ramirez had been trying to essentially delay the process since the very beginning. That he absconded at the beginning when they finally tried him and convicted him. That he's been fighting, taking responsibility essentially since the very beginning.
I'm curious about that dissent, because how much does the sincerity of Ramirez's claim ultimately matter? Like, I know when we talk about a faith practice, it's all about your personal belief, right? But there's also the fact that maybe there is this constitutional right to having someone spiritual present in the chamber with you. And so regardless of whether your actual claim is sincere, the next person down the line who's going to have their case decided on the precedent of Ramirez could be sincere regardless. So does the court have some sort of like responsibility to that future person regardless of Ramirez's sincerity?
Yeah, I think it just goes into whether it substantially burdens their free exercise of religion, right? So if someone's claim isn't sincere at all, then it's hard to say that it's a substantial burden on their religious free exercise. But
Oh, gotcha.
on the other hand, if it's a important, sincere religious belief that a person has, and it's being infringed by a state policy, then it's much easier to make out that it's substantially burdening somebody's religious free exercise. If that makes sense.
Yeah. I think another one of my questions was like, what are the stakes for this decision, right? So Ramirez has been granted the right to have someone in the execution chamber, or they're going to decide in his favor. I think this might tie into the question of what future cases could come down the pipeline, right, that are going to be decided on this. What is the importance of this case, do you think, for like religious freedom claims, for just the Supreme Court in general? Like, what are the stakes?
I think that's a good question. I think this case demonstrated that the court is probably likely to give the benefit of the doubt to the religious claimant about their sincerity, right? The majority noted in its opinion that there probably were some reasons to doubt Mr. Ramirez's sincerity, primarily because he had initially issued a request saying that he wasn't going to need religious touch or vocal prayer, but that he was just going to need his clergy person present. And then he withdrew that request and then submitted another one later. The majority didn't think that was a big enough problem to cast doubt on his sincerity. For Justice Thomas, it was right. It was a big problem, and cast a lot of doubt on Mr. Ramirez's sincerity.
Yeah.
So to answer your general question, though, I think this opinion shows that the court is going to take religious free exercise claims seriously. It's going to take RLUIPA claims seriously, and it's going to put quite a bit of pressure on the state, in this case Texas, right? Or put pressure on them to come up with reasonable accommodations, and not let the state put the burden for a least restrictive alternative on the prisoner, right?
Right.
But is going to put the burden on, or keep the burden where it should be, on the state or on the prison to come up with some kind of reasonable accommodation. So I think that's one of the takeaways, that something like this is serious to the court. I think one of the kind of like unspoken facts in the background that probably helped persuade the court, if I'm kind of speculating or venturing a guess, is that is that this historic practice, right? That this request of Ramirez isn't some newfangled kind of off the wall thing that he wanted, right? Like, I mean, this practice of clergy presence at execution goes back to the founding and even before. And the Beckett Fund did an amicus brief kind of detailing that history, and the court talked about this history in the opinion, and I think it talked about this rich history, right, of having a clergy present. And we may have talked about this in a prior conversation, but religion often comes into play in people's lives in moments where there's a lot of meaning, or where really important things are happening, right? Like at birth, at marriage, at death. Kind of these moments of I guess threshold moments, or moments of moving from one place to another, or moving on from one area in life to another in life. And there's perhaps no more important transition, right, from life to death.
Right.
And so to think that a person might have an interest in having a religious function at that time is totally understandable, right?
Right.
And so I think that's part of the reason why the court was so sympathetic to this claim. And then the second piece is just that there were so many possible accommodations that Texas could have come up with and didn't. right, and didn't offer, that I think it made it an easier case for the court to decide it, with an 8-1 majority instead of like a closer 5-4 decision.
Yeah.
But I think Justice Thomas's dissent kind of shows that, there might have been some reasons to doubt the sincerity of Mr. Ramirez's claims, which I think, his point is pretty well taken. But to the majority, that doubt wasn't enough to make them obviously side with Justice Thomas in saying that his claim shouldn't have been, or that he wasn't likely to prevail on his claim.
Right. I think relatedly, I was curious about, so what you were saying about like times of meaning and threshold spaces. I'm curious about like the sheer length of time that a prisoner spends on average on death row. I think the average was 17 years. And since death row inmates spend so much time on death row, it seems like cases like Ramirez's are going to become maybe more common because these prisoners have a lot of time to adopt a faith practice and to like practice their faith. So I feel like these questions might be becoming more pressing because people are living like entire lifetimes on death row, it seems, and these moments of meaning become more and more common.
Yeah. I think that's a great point that you bring up. I mean, a lot of these individuals, like you said, have been incarcerated for a very long time. Yeah, I think at least kind of in my own experience as a criminal defense attorney, people often seem to find God or to want to approach God or the divine in very stressful time in their lives. And it's hard to think of something more stressful, difficult, or traumatic than being incarcerated, right? So I don't think it's surprising at all that you have prisoners who are bringing religious free exercise claims because I think they have a strong incentive to approach the divine because they are in such a difficult place in their lives, removed from their families, removed from their communities, restricted in what they can do, restricted in who they can contact and how they can contact them, being removed from being able to see their children grow normally and be involved in their families and communities and otherwise. And so, no, I think that's certainly something that would come up. And I think religious leaders in the past who have undergone trials, right, or experience with the criminal justice system, you have Martin Luther King being held in jail, and you have the letters, I believe, from the Birmingham jail. If I'm recalling those correctly. In my own tradition, I'm a member of the Church of Jesus Christ of Latter-day Saints, commonly known as Mormons or the LDS faith. Some of the most inspiring texts in arguably that Joseph Smith he produced when he was incarcerated in Missouri. And then, you think of Christianity generally in the trial and execution of Jesus. So, I do think that kind of contact with the criminal justice system, incarceration, all those things can easily lead to or evoke religious sentiments and religious feelings.
And provide a space for a prisoner to exercise autonomy or to want to make those kinds of choices or free exercise claims. That's interesting. I think this is kind of what we said earlier, but these cases, such as Ramirez v. Collier, are trying to determine whether a prisoner has a right to determine how they die, not whether they die. And some of the other cases we're looking at for this episode have been the recent slew of firing squad cases where you're, again, trying to determine a right in how you die. And I remember you've done some research on reasonable doubt. And I was curious about firing squad executions and how that relates to your research on reasonable doubt. It'd be interesting to bring that up. Or just, I remember it had to do with the morality of the jury, like deciding, like who is the person responsible for deciding, and how does that moral responsibility get played out in a legal setting?
So I had read in my research a book by a professor at Yale, Professor Whitman. He's got a book on kind of the theological roots and the origins of reasonable doubt. And one of the kind of surprising and interesting ideas that he uncovers is that reasonable doubt has this long kind of theological history. And he argues that the idea and concept of reasonable doubt was developed not to protect the accused, as we would normally think, but actually to protect the conscience of the jurors, and to be able to allow them to convict individuals accused of crimes, and then I guess not feel the same amount of moral weight. And so one of the things that he talks about that is hard for a lot of modern folks to understand is just how much pressure medieval jurors felt with convicting somebody. They took really serious the biblical command to judge not, and they felt that if they judged incorrectly, that their eternal soul was in jeopardy, and that to put it more bluntly, that they could go to hell if they falsely convicted somebody. So theologians developed this idea of reasonable doubt in order to kind of assuage or calm the conscience of jurors. And I think that just kind of gets to the idea of how serious it is to condemn somebody, right, to death, or to convict somebody of a crime otherwise. And in our system of the jury trial, it's sort of a collective conviction, right? At least in Georgia, where I practice, the jury conviction requires a unanimous verdict. Everybody's got to be involved in it. And yeah, I think that kind of beckons to this ancient idea of moral kind of guilt, or so to provide jurors with moral comfort because they were doing this terrible, awesome act. And his call kind of at the end of the book is to revive this original meaning of reasonable doubt, that jurors aren't just doing some kind of technical finding of fact. I guess they are in a certain sense, but if, according to Whitman, the historical background of what they're doing is something that carries a lot of moral weight.
Is it possible that the move that some prisoners are making to request firing squad over lethal injection, I mean, lethal injection seems so aesthetic, it's so cosmetic, you don't have to face the same moral decision because it just looks like a vaccine, whereas the bloodiness of firing squad, I wonder if there's a connection there, whether the reasonable doubt standard might apply.
No, I think there's a sense in which things have been sort of sanitized over time, right? We have more distance from the kind of dirty work, if you will, of the criminal justice system than we used to have. I'm just thinking out loud. In the community I live in, there was a move to put the jail right next to the courthouse, which was by a neighborhood. And there was kind of a public outcry, and a lot of signs went up. There's some just down the street near me that say no jail in my neighborhood, and kind of an objection to having the jail nearby for safety concerns, perhaps property value and other things. But often our jails really are kind of out in the middle of nowhere, and individuals who are convicted of crimes are put in these facilities and are kind of far away from the dealings of everyday life. And a sense I've kind of had in my research in the Middle Ages, often these towns where jury trials would occur, they were small towns where everybody knew each other. And if you were convicting somebody, you were probably convicting your brother or your cousin or somebody pretty in close proximity to you. And as the juror, everyone knew who you were, right? And
Yeah.
You had to live with people after the trial, and that isn't really the case for us as much anymore. Maybe in some really small towns, but just the sense in which we kind of live separate from and apart from the criminal justice system. And most people, unless they have a job in it, like as a prison guard or as a judge or a police officer or prosecutor, criminal defense attorney, aren't really going to deal with people, incarcerated people, on any kind of a regular basis.
There's an anonymity that risks seeming to make the decision impartial, like it makes it seem impartial because of that distance.
Right. And it makes me think, and I've heard of this idea that, like in a firing squad, not every single gun has a live bullet. I haven't looked that up. Perhaps y'all can confirm that. I've heard that that's the case. And, I've thought that, probably that way because people don't want to hold the moral guilt for actually doing the killing. I don't know if there's anything similar with the person who does, the lethal injection.
I know there's a similar circuit set up with the electric chair, with pressing the button. I know that's been that's a historical. They use the electric chair to have that same moral. I don't know, but also I think, if I'm not mistaken, that lethal injection, there are some rules set up, I think, by some association of doctors, where it's like they don't want people who are trained in putting people under to have to actually kill someone. It's going to go against maybe Hippocratic oath.
The Hippocratic oath,
right?
Yeah.
So there's something there too, I'm not really fully aware of.
Right. So, and that kind of leads into another area that I think we started to explore, and I hadn't thought about too deeply, but it kind of came out a little bit in our conversation. Is often people talk about, various rights, right to life, or there's been some discussion about, people having a right to death or a right to assisted suicide. You could potentially imagine maybe a religious free exercise argument saying, in effect, my religious beliefs don't believe that it's correct for the state to put people to death, right? I don't necessarily think that would get a lot of traction, but if your religion has kind of a consistent life ethic, right, and that you don't believe that killing is right under any circumstances, you could imagine that a religious belief could also extend to the state not actually really having the right to put people to death either. Now the state is the state and is sovereign in some sense, right, and can has that power, that sheer power to be able to do that. But you're asking this question about kind of what are the impacts of this case and where could things go. I think more practically speaking, we may see additional religious free exercise claims that might come up in the context of an execution chamber. So we just saw laying on of hands. We saw vocal prayer. I think that probably will cover quite a bit, but maybe maybe like a religious anointing, right? In my tradition, sometimes there are religious anointings that are done for the healing of the sick, right? To use an oil on the head of an individual. That's just one example I could think of. That wasn't necessarily covered in the Ramirez decision, and maybe something like that might come up. I think we talked about maybe somebody requesting a baptism or a sprinkling right before execution. I don't know if that would ever result, but I think if someone did come up with one that was sincerely held, and they really needed it, or felt that they needed it as required by their religion, the court might take a hard look at something like that. Now, as I stated earlier, the tradition of something I think really helps. And in this case, and in this line of cases with the presence of clergy and prayer and laying on of hands, those are kind of entrenched traditional religious practices that are pretty well known. So some of these, certain religious requests that are more uncommon or less traditional, I don't know how sympathetic the court will be to those or not, but you could imagine using Ramirez to Collier as precedent, these individuals or certain individuals may be trying to add certain religious practices on. Now, again, these won't even make it up to the courts if the state or the prison systems accommodate or find ways to accommodate these religious requests,
Through
right?
RLUIPA,
Through
basically.
RLUIPA, right?
Yeah.
And if they are able to work it out amongst themselves, right, they won't ever really make it up to the courts. So, yeah.
I do want to ask, considering the right to life claim we were talking about, the one thing that I seem to see as a difference, even though people are talking about the abortion debate in terms of cases like these, it seems as though it places an emphasis on like the punitive nature of our justice system. Because I can imagine someone who is very pro-life saying, well, those babies are innocent, right? And they want to say there should be like this punitive justice for someone who's committed some sort of moral wrong, where the right to death or the right to life, that becomes blurry for them because they do believe in this punitive nature of the justice system. They don't believe in rehabilitation. They don't want prisoners to, in this case for Ramirez or for other prisoners, find a faith practice, be rehabilitated in the justice system. I think that that's part of the debate where you want to argue that a child is completely innocent and these people don't deserve that same level. I don't think I've seen people broach that because that's a topic I often see come up when we're talking right to life. And I wonder if that would complicate, I guess, the correlation, or maybe just shed a light on, again, our punitive view of the justice system and what it should be doing in society.
Right. And I think that, like, as you suggest, that might be a reason why a pro-life person, right, might also be in favor of the death penalty.
Yeah.
And I think the logic would, I think the logic to that would be the child is innocent, but the person convicted is not innocent, and then somehow is forfeited their right to life by their actions.
You see these people on death row saying, like, I'm not the same person I was 12 years ago. And to some extent, that barely does ring true. Like 12 years is a long time, for example. And so you look back, and I'm sure many prisoners could have this experience of saying, I don't recognize that person. It's been so long.
Right. Yeah. So that brings up the question of, like, some of what I've tried to do in the criminal law and religion blog is just kind of explore just how close religion, and particularly the Christian tradition and in our Western context and our Western legal system, how close they really are in history and how much overlap there's been throughout time. And now, as the two spheres of religion and state have arguably separated more over time, there's still this question of what role does redemption, forgiveness, penance, repentance, I guess even reformation, or I think in a more secular term, rehabilitation, right? But maybe in a religious way, repentance, redemption. What role does that play, or should it play in the criminal justice system? And I think you're right. I think, on the one hand, there are people who've committed, horrendous acts, or allegedly committed them or have been convicted of them. And then, the question is, can they be redeemed, right? And for my own tradition, I don't personally believe that there's anybody who's beyond the point of some point of redemption, right? Some people may not choose it, but it's possible for all, no matter what they've done. And a quote by Brian Stevenson, who's a person who influenced me a lot, is a person, basically, when I'm paraphrasing, shouldn't be defined by the worst thing they've ever done, right? If that was the case for all of us, that would be a pretty awful, right?
Yeah.
Because you and I and all of us may not have committed a horrendous crime, but we all have certainly done something or things that we're not proud of. And do we want to be branded and defined by that forever? And I think the answer is no. And is there some kind of place for for mercy, some kind of place for redemption, for forgiveness. I like to believe that there is. And when it gets into how that interacts with the rule of law and justice and the state, it's difficult. And a lot of ink has been spilled on these intersections of religious conceptions of justice and more secular or philosophical conceptions of justice, and how they intersect. That's what I think so interesting about something like issues of criminal law and religion, is it just brings up such a rich array of all of these different areas and ideas in our culture, in our history, and in our society, right? And I think that would be better off to look at our history, our tradition, or I should say traditions, histories, in our context, in the United States, more Western, but also Eastern and otherwise, and to see what kinds of good things we might be able to bring to bear from those traditions onto our legal system to make it more just and to make it more conducive to the common good, so to speak.
That's part 2 of our 2-part series, The Right to Death, with Peter Wozniak. Thank you for listening.
Canopy Forum and the Interactions podcast are distributed by the Center for the Study of Law and Religion at Emory University and produced by Anna Knutson and Ethan Anthony.
You can follow Canopy Forum on Twitter or Facebook, follow Interactions on Instagram, and subscribe to Interactions on your favorite podcast platform.